Thank you, Christy. I'm speaking to you from the Iowa State Bar Association CLE room. I've not been in here before, and we're kind of starting on railroad time. I guess this was originally a railroad building. So I am with the Area Prosecutions Division and specifically assigned to Medicaid fraud. I'm going to be talking about 2/3 of the work we do, which is provider fraud. 1/3 is patient abuse and neglect, which I know is a very significant issue for us, but this CLE is primarily going to focus on that. So starting off with your typical disclaimer, it's just for educational purposes, etc. So I'm going to talk a little bit about Medicaid, and this is an excerpt from the governor's proposed budget, which tells us about the size of Medicaid. And so I've underlined in red there, telling us about the Medicaid program that since 2000, it's expanded from less than 250,000 people to now more than 400,000. And during that time, its costs have grown significantly, now up to $3.5 billion. The next slide is from that same budget proposal by the governor. And we can see on the right-hand side, the education is $3.5 billion from general fund appropriations, and the next biggest chunk is the health and human services. And what's significant, just briefly, is that a large chunk of that is the state portion of Medicaid. So about 1/3 of the money for Medicaid comes from the state and 2/3 by the federal government. So when you add what's coming out of the general appropriation to the federal match, FMAP it's referred to, that makes the total budget about $3.5 billion. You can see that it's pretty much the largest thing in the state of Iowa for our budget. So I'm not going to spend a lot of time on this, but just briefly, the Medicaid Fraud Control Bureau is part of the investigation division of DIA, and of course DIA is sort of a polyglot agency. We have cover everything from food inspectors, of course health facility inspectors, assisted living, licensing, bingo, so there's a lot of things in there, and obviously the ALJs are a part of the DIA as well. So the investigators for the Medicaid fraud have the authority of peace officers, but they don't carry firearms. We're a grantee, as I said, of the Health and Human Services Office of Inspector General, so 100% of our time is spent on those activities of the grant mission. And I mentioned this before, but the mission is both to detect and enforce laws on provider fraud, but also patient abuse and patient neglect in facilities that receive Medicaid funds. So the Medicaid Fraud Control Bureau, there's 49 of them. All the states except North Dakota have Medicaid fraud control units, and this is a citation to the Code of Federal Regulations, which tell us how to do our work. So the scope and purpose of a Medicaid Fraud Control Bureau is to, it's under the Social Security Act, which is where Medicaid falls, and of course Iowa has decided to participate in Medicaid, has a state plan that's approved by the Centers for Medicaid and Medicare Services, CMS, and that slide obviously talks about the funding to establish it. So our relationship with the single state agency. So the Department of Human Services for several years now has implemented the Medicaid program through the Iowa Medicaid Enterprise, but these rules tell us that the Medicaid Fraud Control Unit has to be distinct and separate from the Medicaid agency, that being DHS and its Iowa Medicaid Enterprise, IME, and that the Medicaid agency, DHS, has no authority to review the activities of the Medicaid Fraud Control Unit, and the unit doesn't receive any funds from the state agency, sometimes referred to as the single state agency. The administrative rules for the Medicaid Fraud Control Bureau are found there, 481 Administrative Code 73. And I'm going to spend a little bit of time talking about the administrative subpoena powers to third parties such as banks, and also talk about providers. So I'll just stop for a second and, why would this be of interest to government attorneys? If you're a city or a county that has a hospital, it's highly likely that you're signed up to be a Medicaid provider. If your county, if you represent a county, you may have case managers that are still involved, or group homes that access Medicaid money, so you might be signed up as a Medicaid provider for that intermediate care facility or ICF, MR, one of those types of facilities. So taking a step back and talking about administrative subpoenas, because we do utilize them, if not on a daily basis. There's several administrative subpoenas coming out of our agency per week. And so one of the older cases is United States versus Morton Salt, where the Federal Trade Commission was not only trying to enforce the act, but also investigate unfair trade practices. And the business had complained that the administrative subpoena was a fishing expedition. And in the decision by the Supreme Court in 1950, it discussed the power of that administrative agency to get information from those who can best give it and who are most interested in not doing so. And they said that it does not follow that an administrative agency charged with seeing that the laws are enforced may not have and exercise the power of original inquiry. In Morton Salt, it went on to say that this here the FTC has a power of inquisition, which is not derived from the judicial function, but is really more analogous to the grand jury, which does not depend on a case or controversy for power to get evidence, but that the administrative agency can investigate merely on suspicion that the law is being violated. And then finally on Morton Salt, when the investigative and accusatory duties are delegated by statute to the administrative body, it may take steps to inform itself whether there is probable violation of the law. So let's look at 4 cases on administrative subpoenas in the state of Iowa. They're not exactly in chronological order because the last one is a little bit of a twist on just generally administrative subpoenas and their enforceability. So obviously, the Medicaid Fraud Control Bureau in our state issues a subpoena under statute under 10A, which is the code section of the Department of Inspections and Appeals. That subpoena goes out, and if it's not complied with, we would go to court, to the district court, to seek enforcement of the administrative subpoena. So the first case is the Iowa City Human Rights versus Roadway Express, and it has the just general principle that agencies are vested with broad authority to issue investigatory subpoenas within their field of expertise. That was in 1986. And the Ombudsman case from 1993 stated some of the same things, but obviously it went on to talk about the enforcement of the subpoena is the rule and not the exception. The third case in 2001 was a consumer protection action by the Attorney General's office against Publishers Clearinghouse, and the court was really expanding on those earlier decisions to state that the legislature granted plenary power to the Attorney General to enforce consumer protection laws, and courts are not going to modify a subpoena unless it seriously threatens to unduly disrupt or seriously interfere with their business. And the burden is going to be on the party receiving the subpoena who is opposing its enforcement. Now the fourth case that I mentioned that's not in chronological order is a little bit different. In the top box is describing the facts of this case, which has to do with the insurance commissioner, and the court appointed an insurance company liquidator, and they issued an administrative subpoena to an accountant for the insolvent insurance company, and the insurance company sought to quash the subpoena. So what this case is about, and it's a little bit narrower, is that there's already ongoing litigation involving the agency, and then this was, as we'll see, an attempt to use an administrative subpoena outside the litigation. So the court said that, you know, it requires notice to opposing parties prior to taking depositions, and the use of by the liquidator to use a subpoena he's already a party to a suit. He should be consistent with the rule and give notice. And the Supreme Court in 1989 went on to say that when there's a pending suit where the liquidator is a litigant, reasonable notice must be given of the subpoena application, and it must be given in writing to every other party to the action, stating the time and place of examination. And the court went on to say that to do otherwise would really undermine the rules which are aimed at the elimination of trial by ambush. So if we, on the cases, this is not all the cases on enforcement of subpoenas which are from an administrative agency, but it's a good sample, and we can summarize by saying that these subpoenas are going to be enforced if they're within the statutory authority of the administrative agency. The second thing is that they have to be, of course, reasonably specific, that they not be unduly burdensome, and they must be reasonably relevant to the matters under investigation. I think a lot of the fight, as you can imagine, not that it comes to this very often, would be, is it unduly burdensome if the administrative subpoena says we need to produce these records within 5 days, and that's not a reasonable time to produce them. It's, as you would expect, a matter that's typically negotiated for extension of time if the party who's received the subpoena is stating that they need more time to respond to the subpoena. Now, the second bullet point on this slide is providers have signed a provider agreement agreeing to maintain records and turn them over. So if let's say a clinic wants to participate in the Medicaid program, they're going to sign a provider agreement, and one of the paragraphs in that is going to, it does state that the clinic will maintain its records for 5 years, and upon the request of either the department or us, the Medicaid Fraud Control Bureau is going to turn those records over to the Medicaid Fraud Control Bureau. So with a provider, there's really no legal basis. I'm going to get into this in just a little bit further, but they don't have a legal basis to say you need to give me a subpoena, because they've already agreed, and the federal rules support this, that they need to maintain those records and hand them over. And I also am going to touch on, because we're talking about Medicaid healthcare, the HIPAA laws and whether the Medicaid Fraud Control Bureau is HIPAA exempt. But before looking at HIPAA exemption, I want to take a look at an earlier Iowa case, and that case is Chitester versus Needles back in 1984. And this case was an instance where the Polk County attorney utilized Rule 5 of the criminal procedures for a county attorney subpoena to a clinic to produce records. So this clinic was a counseling clinic, and the keeper of the records, Chitester, refused to turn them over, and then a contempt action was brought. And so I have 3 bullet points here, and I want to focus on the second and third. The actual holding of the court at that time, the first bullet point, which I think is not as important today, it was talking about whether forcing somebody to hand over records was testimonial based on the statutory privilege of patient-physician. And I think in 2006, the Heemstra case, actually there was a couple cases before that, but I think that part of the holding is not nearly as valid as it was, but the other 2 points are the second and third bullet points there are the ones I want to focus on. And that is that if somebody applies to be on Medicaid and the taxpayers are funding their care, is it permissible for the government to then go in and look at the records to see if the records support the claim made by the provider? And so back in 1984, the Iowa Supreme Court was saying, yes, it's not an impermissible invasion of constitutional right of privacy, and the privacy interests of the patients is yielded to the state's interest in well-founded criminal charges and fair administration of criminal justice. Okay, the Medicaid Fraud Control Bureau is HIPAA exempt. So under 45 CFR Part 164 HIPAA, the easiest way to explain this is that it is a health oversight activity, and you have the citations there as to why that gives authority that why the activities of the Medicaid Fraud Control Bureau are health oversight activities, and then secondly that the minimum standards do not apply. So the minimum necessary standards do not apply. What I'm referring to there is that the section that says that when using or disclosing protected health information or when requesting protected health information from another covered entity, a covered entity must make reasonable efforts to limit protected health information to the minimum necessary to accomplish the intended purpose of the use, the disclosure, or request. So for the Medicaid Fraud Control Bureau doing health oversight activities, the party producing this information does not need to engage in that, well, what's the minimum necessary part of this record that I need to turn over? Quite frankly, that's pretty helpful to the provider, because otherwise they would have to be engaging in an analysis of what is the minimum necessary amount of information that they need to turn over. So for those reasons, or the citations there, the minimum standards, minimum necessary standards of HIPAA don't apply to Medicaid fraud. The HIPAA exemption letter, and this is kind of a wordy PowerPoint, and I'm probably violating the rules on having too much information on one slide here, but when we get questions from providers about, well, I can't turn this over to you because of HIPAA, they're not familiar with it yet, if they haven't been audited and they haven't looked at these rules and aren't familiar with it, we give them a letter which states that, and they can go back and reference the parts of 45 CFR Part 164, that Medicaid fraud is a health oversight activity, and there's further citations to Medicaid fraud control units and the information that they seek. And then I'm referencing it again, the minimum necessary standards do not apply, so that's all contained in the HIPAA exemption letter. And generally we found that providers who their first time around receiving a request from Medicaid fraud, that after they look at this they realize that yes, it is an exception and they can hand over the information. There is Part 2 information which gets way beyond what I'm talking about here, and that is 42 CFR Part 2, which is substance abuse and alcohol treatment, which has an extra layer of protection which gets a little more cumbersome. But just generally speaking, this HIPAA exemption letter is going to explain to the provider that yes, they are authorized by HIPAA to hand over their records of Medicaid patients to us because we're a health oversight agency. quickly, this is a excerpt from the administrative code, so 481, section 73 on Medicaid fraud. It talks about what we do when we investigate and sort of come up with the results of our investigation. But I'm going to summarize that in 6 points on the next slide. So that basically you could say there's 6 things that Medicaid fraud does. Number one, we would refer to the United States Attorney either in the Northern or Southern District for criminal prosecution. Secondly, we could refer the case to the county attorney for state criminal prosecution. On conflict of interest cases or cases where there's not resources in that county or expertise, they can ask under the statute that governs county attorneys in the code, ask that the Attorney General prosecute the case. And so I go around the different parts of the state at the request of county attorneys and prosecute criminal actions. The third point there is referring to the United States Attorney, civil attorney for federal false claims. The fourth is to refer to the State Attorney General for state false claims, and that's the second part of this presentation, our fairly new Chapter 685, the State False Claims Act. And lastly, based on our investigation, we might refer to other agencies, maybe if it's not criminal or doesn't quite rise to the level of a false claim, we're mandated to give that information back to the single state agency, the Iowa Medicaid program, so they can do what's appropriate, perhaps licensing boards if we find out possible violations. And the last one, which is an important function, is making policy recommendations to the single state agency, to the Iowa Medicaid program. So I'm just going to quickly talk about typical provider fraud referrals to county attorneys and 2 typical referrals. The first one is tampering with records under the forgery statute. So the scheme is essentially cooking the books. The 3 elements, and this is, as you think about this, and think about the facts that it might apply to, it's fairly friendly to the prosecutor to get an aggravated misdemeanor conviction. So having no privilege to do so, falsify a writing or record with the intent to deceive or conceal a wrongdoing. And there's 3 cases, there's about 5 total cases, 4 reported, the Acevedo, Romeo, and Walker cases. Acevedo was a guy who was under suspension. He went to the Woodbury County Treasurer's Office to try and register a new car, and of course he was prohibited because he was under suspension and used a false name. Conviction upheld. Romeo was actually a conviction of an attorney who was representing some guys who had stolen a skid loader, and he knew that they had stolen the skid loader, and he wrote up a bill of sale that would make it look like these guys had actually purchased the skid loader from someone else. He got convicted, conviction upheld. And Walker was a guy who was in a simple misdemeanor trial. He told the magistrate that he had served a juvenile and gave the subpoena and filled out the back of it saying, look, I'd served this person the day before, and he was convicted, and that conviction was upheld. So the typical scenario for tampering with records would be a provider after the fact creates service records to make it look like they performed work for which they already billed. Fraudulent practice under 249A.8, and I realize that they've changed this now. It's 249A.51 is the correct citation now. It's the same statute. But it's a fraudulent practice in the state of Iowa to knowingly make or cause to be made a false statement of material facts or knowingly fail to disclose material facts in application for payment. And so that sort of typical scenario would be the provider bills for work they did not provide or for more work than they provided. Another scenario would be somebody who bills as if they were a doctor, and of course that's going to be material to the single state agency because they wouldn't have paid for as if it was a doctor if you weren't a doctor. Let's switch gears and talk about the False Claims Act. So Iowa adopted the False Claims Act in Chapter 685, and the spring of 2010. It was effective on July 1, 2010. So we're just starting to see causes of action accrue because obviously it wouldn't be retroactive. So, and I'm just going to ask the question, is it important here in Iowa? And so this is from, and I'm citing from the public record here. I know a little bit more about this case, but so the Clinton Herald was writing an article about the city of Clinton ambulance case. So the facts of this case: in September of 2008, a former Clinton city firefighter filed a federal false claim suit, and as we'll see, they'll be under seal, and this was on behalf of the United States government. A year later, the United States declined to intervene, and I'm going to go through some of the statutes of our state statute, which tracked the federal one. The case was kept under seal until a little bit longer after the United States declined, and then approximately a year later, the city signed a settlement agreement with the United States and Schulteis to pay the U.S. government $4.5 million over a 10-year period in equal installments. So there's one example of why the false claims statute is important. There can be multiples of damages, as we'll see. Penalties, if it's brought by a relator, by a qui tam relator, they can get attorney fees as well. So here's a little bit of history. The False Claims Act, I'm talking about the Federal False Claims Act, started in the Civil War. And this citation from this case in California is telling us that the War Department found itself at the hands of unscrupulous and corrupt government contractors. For sand, the government often got, for sugar, the government often got sand. For coffee, rye. For leather, something no better than brown paper. So the government can initiate the False Claims Act, the Civil False Claims Act, on its own directly, or a whistleblower, somebody who's inside and knows about it, can start a qui tam action on behalf of the government. In what continuing education event would be complete without some Latin? So qui tam, there's the full qui tam pro domino, etc., which means who pursues this action on our Lord the King's behalf as well as his own. So unless you're a Jesuit graduate of a Jesuit school and learn Latin, it's always good to have Black's Law Dictionary. Or if you're perhaps from the 1% of Switzerland that speaks Romanish, which is actually an official language of Switzerland, you might be able to figure out what that means. But the rest of us, not so much. So the decision to intervene. So when a qui tam relator, that is that whistleblower, files the suit, it's automatically under seal so that nobody knows about its existence. So and quite frankly, a lot of these times the qui tam relator will still be employed with the company, so they don't want the company to know about it. So it's automatically under seal for 60 days, and then after that the state can apply for extensions of the seal to keep it sealed, to give the state time to analyze the case, to decide whether or not the state wishes to intervene or let the qui tam relator on their own pursue the action and perhaps get a fairly large qui tam fee, could be 25% of the total recovery if they're, I think it varies whether the qui tam relator, whether the government intervenes or not. Some of these cases will stay under seal for quite a long time. The ones, because there's a lot more history and a lot more action in the federal courts on qui tam actions, they can sometimes stay under seal for years. Lately, there's been a trend by the federal judges to try to rein that in and get the government to decide whether or not to intervene and not give so many seal extensions. So in federal court, if it's a claim that both Medicare and Medicaid was defrauded, the Medicare, the United States Attorney will be handling that, and then all the states if we have a qui tam statute, will be named as additional parties. So Iowa has started to get named under these sealed lawsuits all around the United States. So it'd be the the U.S. Versus this whatever defendant company it is, and it will also, besides the U.S., name 30 or so states that have false claim statutes, because if we have a false claim statute and the case is ultimately successful, the relator is going to get a share of the state's portion as well. What can cause liability? 7 things. The third one is conspiracy to do any of the other 6. The first 2 are the most important. I'm going to spend a little time talking about those. The others about possessing the state's money and not returning it or buying a pledge from one who may not sell aren't as important. So really the top 2, the false claim or the false statement material to a claim, are the 2 important ones. And I've talked about this before, the damages. It can be up to treble damages, and this is all in the judge's discretion, $5,500 to up to $11,000 penalty per false claim that's submitted. Statute of limitations, it has to be brought within 6 years or within 3 years after the government knew or should have known, but in no event more than 10 years, whichever occurs last. So here's my slide on the relator share. So if the state intervenes, which is really a great deal for the relator because they've brought the suit, it's under seal, the state examines it, decides to intervene, and then the state takes over the prosecution of it, the relator is going to get at least 15%, perhaps up to 25%. If the state doesn't intervene and lets the case go forward, the state can dismiss it if it believes that for whatever reason that you shouldn't go forward. But if the state doesn't intervene and the relator goes forward with it, the relator is going to get 25 to 30%. So you remember the slide we talked about the City of Clinton firefighter. He got a pretty good, can't remember whether he got 25 or 30% of that $4.5 million, but he came out pretty well for that. And by the way, of course that's filed in federal court. Chuck Grassley is the champion of the False Claims Act, and I'm going to talk about some amendments here, but he's very interested and well known around the country as being pretty much one of the leading legislators on this. So it's only by a preponderance, and I'm going to talk about the proof of what they have to prove here after we talk about civil investigative demands by the Attorney General. So the Attorney General has the right to request the production of documents or in interrogatories and get oral testimony from folks while investigating a possible false claims action. I'm going to give you what I believe would be some of the jury instructions, and I'm going to look at some of the points that I think are the most significant. I filed one false claim. It was not a relator case. So our new statute, and like I said, I've filed one on behalf of the state. It's currently stayed because one of the principal defendants is under federal indictment, so the case is kind of stalled out. But here's what I believe the jury instructions would look like. So the first 2 slides are the marshalling instructions for the presentation of a claim and then a false statement. And when we look down at the bullet points at the bottom, you can see that the state's going to have to prove by a preponderance that the defendant knowingly presented or caused to be presented to the state a false or fraudulent claim for payment or approval. And then the other big one is the false statement, where the defendant knowingly made or used or caused another to make or use a false record or statement that was material to a false or fraudulent claim. One of the significant points about this statute is that the word knowingly is defined a lot more broadly than what you and I usually think about the word knowingly means. So I've highlighted in the red box there, so the top bullet point is what we generally think about somebody having actual knowledge of the true information. But the government is frequently going to be relying on the second two bullet points, which are deliberate ignorance or reckless disregard, so that the defendant acted in deliberate ignorance of the truth or falsity of the information, or they acted in reckless disregard of that information. And it's also not necessary for the plaintiff to prove that the defendant acted with the intent to defraud. So those alternative ways, deliberate ignorance and reckless disregard, are very powerful in this statute. And in that regard, there's a case, I'm going to cite just one. It's United States versus Kryzak. George Kryzak was from Czechoslovakia. He was trained as a physician over there. He immigrated to the United States and did all of his internships, and eventually ended up as a psychiatrist in Washington, D.C. And at one point in his private practice, he had his wife doing the billing. And although the court in this case, it's from 1997, was generally laudatory about what a good physician Dr. Kryzak was, the real problem came with how his office created the bills. So Dr. Kryzak said, I didn't know how this was being billed. I'm not responsible. But the court states that the basic method that was utilized by Dr. Kryzak was to assume that all of the visits were 50-minute visits. So when you go see the doctor, a lot of those codes are timed. So if you see the doctor for 20 to 30 minutes, it would be one code. The doctors can get paid more if it was a 50-minute visit. So what the Kryzak clinic did was they, Mrs. Kryzak, whose name was Blanca, frequently made the assumption that all the visits to the doctor were 50 minutes without checking on that. And the court said the net result of this system, or more accurately, non-system of the billing, was that on a number of occasions, Mrs. Kryzak submitted bills for the 45 to 50-minute psychotherapy session, and when they really couldn't have occurred. And the court then looked at a couple of days where, if you added up all these 45 to 50-minute visits, the doctor was seeing patients for, on one day, 21.5 hours, on another day, 23 hours. And so there are a lot of other cases, but I'm just raising this as just to give you a factual example of how a clinic can still be liable. Maybe they're not liable criminally, but they could be liable civilly for even up to treble damages based on deliberate ignorance or reckless disregard. This slide shows you what I believe might be a typical jury instruction for deliberate ignorance, and I've highlighted that the defendant deliberately closed his eyes to what would otherwise have been obvious to the defendant, or in reckless disregard, without properly considering the claim's truth or falsity. So if an underling comes to somebody in the clinic and tells the higher-ups, the doctors, hey, we're billing this wrong, doctor, we're overbilling the government, and the doctor says, I don't want to hear about it. And if the jury believes that, I think it's easy to see by preponderance of the evidence that the government could prevail on a false claims case based on that reckless disregard of the truth. Let's look at federal case law. Now, the Iowa False Claim Act closely tracks the federal. On the right-hand side, 31 U.S.C. sections 3729 to 3730 is where you can find the federal statute. But the Iowa statute very closely tracks it, and the letter, you can't really read it, it's small, but the letter on the left-hand side is a letter from the Office of the Inspector General finding that the Iowa statute so closely follows the federal that the state of Iowa is going to be given a 10 basis point bump up on any recovery. And occasionally you read about these in the papers about large pharmaceutical companies paying, up to $1 billion for off-label marketing and so forth, and then Iowa would get a share. Well, after now, since we have this compliance with having our statute closely following the federal, we get a 10 basis point bump up on those recoveries. Sovereign immunity to the states, and I'm going to quickly turn to immunity, or is there immunity for municipalities, which is more interest to you folks. But the case of Vermont Agency of Natural Resources in 2000 said that the False Claim Act does not subject a state to liability in federal court by a private individual. In other words, the state is not a person. So municipal liability of more interest, Cook County versus the United States XREL Chandler, 3 years after the Vermont case, the Supreme Court said that local governments are persons subject to qui tam suits. The facts in that case was that the National Institute of Drug Abuse was made a grant to Cook County Hospital for a study, and Chandler, who ran the study, filed the qui tam action claiming that Cook County had submitted false statements in an effort to obtain grant funds. So the Miss Chandler prevailed there, and there was the municipality was found that it could possibly be liable for making false claims to the federal government, in this case the National Institute of Drug Abuse. The analysis that the court did in Chandler was they were looking at in 1986, this was the argument Cook County was making, hey look, they've increased the damages from double to treble. And so Cook County was arguing that essentially this remedial provision was now punitive and you can't do that. But the court decided that the False Claims Act damages multiplier has a compensatory function as well as a punitive one, and further stated that there's no provision for prejudgment interest or consequential damages, so those getting treble damages could be seen as part of that. And the court's concluding that the treble damages certainly does not equate with classic punitive damages. So in your classic punitive damages case, the jury would have the freedom to award a very large punitive award, whereas in the False Claims Act, the judge is going to make that decision, and it's only limited to treble, and for those other reasons stated, Cook County lost in its argument. Qui tam relator must be the original source. Here's another facet of the qui tam aspect, the whistleblower. And in 1943, the United States government was investigating some electrical engineers who were, as the facts show, collusively bidding on this public project, and they were convicted. So several of these guys were convicted. So Mr. Marcus, the relator, was sitting at home and reading the newspaper in Pittsburgh, or was in the Pittsburgh area, and he read about the convictions in the newspaper and thought, hey, maybe I should go down and file a lawsuit against these companies and the individuals who did this to recover for the United States government. So this is sometimes referred to as a parasitical lawsuit, but the court said, well, the Supreme Court in 1943 said, well, that's the way the statute is written, so we're stuck with it. And Congress was not very happy about this, and immediately, very soon after, amended to add the original source requirement. So to get away from the parasitical lawsuits about somebody who doesn't have any insider knowledge, somebody who doesn't have anything of value being rewarded by the False Claims Act. The idea with the False Claims Act is they want that insider who has that knowledge to step forward and give them this bonus for doing so. So the court's going to dismiss a relator's action unless he or she is the original source. So that means either that they have voluntarily disclosed to the state the information on which the allegations or transactions are based, or that they have something independent which materially adds to what is already publicly disclosed, and they voluntarily provide that to the state. I, at any given point, have about 90 cases that are under seal around the United States. I first receive a disclosure statement, sometimes followed as quickly by a week with getting served with a copy of the federal complaint, you know, whether it's in a state on the east or west coast. And since they're generally naming both Medicare and Medicaid, the United States government takes the lead, and the various state Medicaid fraud control units get together and act as an ally to the U.S. government, which is typically investigating the Medicare aspect. Collective knowledge. By this, I want to look at what knowledge in a large organization does one individual have to pin liability on that corporation. And here the D.C. Circuit in 2010 didn't like the jury instruction that had been given, which they felt allowed the jury to aggregate the states of mind of multiple individuals. However, they did point out that if you're a larger company or entity and you structure your organization to deliberately prevent any one person from learning all the facts, if you can show that that was done, that might be acceptable. But generally, you're going to have to show that somebody had the requisite state of mind, of course, remembering that it's a lot easier under the False Claims Act because we have deliberate ignorance and reckless disregard as ways to prove knowledge. Vicarious liability. So your entity has a rogue employee who you didn't want him to do this, you didn't want him to submit false claims to the state or federal government, but they did it anyway. Is your entity liable? There's 3 circuit court opinions, the 1st, 5th, and 11th, that impose vicarious liability, and these are not all, you'd have to read them to get the different flavor of them. But generally that's what you're going to see, is that the entity is, they're going to look at the restatement of agency. If the employee was acting within their scope or their apparent scope of their work, then the employer is going to be liable. Case law from the 8th Circuit, there's 2 district court cases. One is in the Eastern District of Missouri, which said that there can be liability under the False Claim Act imposed under respondeat superior. And the second case in 2001, this was, I'll give you a little bit of the facts of this case. The contractor was rehabbing some military housing in South Dakota. The superintendent who was out there doing the work uncovered asbestos, and instead of properly handling it, he covered this up and continued to submit bills. And here the court said if the person's within the scope of their employment or with apparent authority, regardless of the principal's knowledge, they're going to impose vicarious liability on the company. Retaliation. Under the False Claims Act, there's this employment law provision, which is really, when we look at it here in just a second, we're going to see it's really quite similar to what you'd see under probably retaliation under Title VII and that type of thing. So under Iowa Code 685.3 sub 6, it says that any employee, contractor, and agent, so you don't have to be a direct employee, you can be a contractor, if you're discharged, demoted, suspended, threatened, harassed, or in any other manner discriminated against because of the lawful acts done by the employee to further or with others to further an action, the entity can be liable. And the relief is reinstatement with the same seniority status and 2 times the amount of back pay, interest, compensation, reasonable attorney fees. I think that's, without looking at them, I think that's pretty similar to what you get in Title VII. And it's got a similar personal injury type statute of limitation of 3 years. So it's shorter than the substantive False Claims Act statute of limitations that we looked at earlier. Here's a real recent case from the 10th Circuit, which talks about the plaintiff has to show that the defendant had been put on notice that the plaintiff was either taking action in furtherance of a private qui tam or assisting in the False Claims Act action brought by the government. So in other words, merely informing the employer of regulatory violations without any more does not provide sufficient notice, because it gives the employer no suggestion that the plaintiff is going to report such noncompliance to government officials. Okay, Kmart. Seems like a funny thing to put on there. So 2004 was actually not a great year for those of us fans at Kmart. Why? Because Martha Stewart was convicted of violating 18 U.S.C. Section 1001. So my last slide, and then we'll have a little time for questions, is there is a special obstruction of criminal investigation of healthcare offenses in the Federal Criminal Code under 18 U.S.C. And it is a lot stronger than the state crimes that could be brought against somebody who's obstructing justice under our Chapter 719, specifically Section 719.3, which is an aggravated misdemeanor to destroy, alter, conceal physical evidence, which would be admissible. Under 1518, it's a 5-year federal, 5-year potential imprisonment in federal prison for anybody who willfully prevents, obstructs, misleads, delays, or attempts to prevent, obstruct, mislead, or delay communication of information or records relating to a violation of federal health care offense to a criminal investigator. And there's at least dicta in a case from the 10th Circuit in 2009 that says that agents of Medicaid fraud control units, such as our Medicaid Fraud Control Bureau, would be a criminal investigator. Of course, that's going to be up to the United States Attorney, but it kind of reminds me, and I'm going to finish up on this, the joke that I heard a commentator on public television say, the 2 rules of crimes in Washington, D.C. are, number 1, most people don't get convicted of the substantive crime, they get convicted of the cover-up. And the second rule is nobody remembers rule number 1. So on that note, I'm going to see if Christy can tell me if we have some questions.
Looks like our first question.
All right, the first question is the legal authority of the Medicaid Fraud Control Unit to obtain mental health records under Chapter 228. And then Chapter 125, and then the HIV AIDS test records under Chapter 141A. The last one, I don't think I've ever looked at that. The other two, I think are, and this isn't going to be the greatest answer, but they're directed at protecting the individual. And I think Chittister makes it clear, at least that would be my viewpoint, is that if you decide to sign up for Medicaid, it's going to be a balancing of those privacy interests. And so once you sign up, once you're a Medicaid patient, that's going to be the argument that I'm going to make. The government has the right to inspect those records. Now, obviously those records were designed to protect the individual. We don't want to, we're not interested in finding out anything about the recipient. We're trying to figure out did the provider actually provide those services or not. So, second, will you be able to obtain copies and let Christine know that?
Yes, I'll go ahead and send out copies of the PowerPoint afterwards, so you will receive a copy of that.
Okay, the minimum standards is the last question. The minimum necessary standards, so what I understand that to mean is that the provider, when they're handing over records, they might say, well, to comply with this request, I only need to give a part of this information. But that minimum necessary information does not apply. So I guess we're going to get more we're going to get more of the record, so that would be one of the implications. But as I stated before, we're not interested in what the recipient did. We're only interested in whether the provider provided that. So we are under federal mandate to protect all of our information. So there's under supremacy clause, one could say under 42 CFR 1007, there's a requirement under federal law that we protect this information and not use it. And I go back to Chittister again, that if you sign up for Medicaid, you're receiving Medicaid, there's an expectation that your records might have to be looked at to make sure that the government is getting for what it paid for.
Looks like we had one more question. Can you repeat the CFR site?
I'm guessing maybe the one I just mentioned. Okay, thanks, Anne Marie. So 42 CFR Part 1007, I can't remember if it's like .9 or .11, but there's a section in there that talks about requiring that Medicaid fraud control units have necessary privacy safeguards to protect that information. So actually, I don't think it'll take you a real long time to find that, because 42 CFR Part 1007 isn't very long, and if you just skim down to the privacy safeguard section, I think you'd be able to find it.